Good morning. Welcome to the First Appellate District. We have 3 cases scheduled to be argued this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed this morning. The first case is C-240352, Costanza versus City of Norwood.
Good morning, Your Honor. Scott Thomas for Tina L. Costanza, ready to proceed.
Thank you.
Good morning, Your Honor. Scott Thomas on behalf of the County of City of Norwood, ready to proceed.
Thank you. The second case is C-240284, Edward Wilson versus CSX Transportation.
Good morning, Your Honor. Thomas J. Joyce III for the appellant, Edward Wilson, you're ready to proceed.
Thank you.
Good morning, James Carnes for CSX Transportation, Inc., and we are ready to proceed.
Thank you. And the last case is C-240282, INRI GRB. The attorney's present.
Scott Greenwood with James Moskowitz for Appellee Taylor Dunlap, ready to proceed.
Thank you.
Good morning, Your Honors. Jonathan Hilton and Jeffrey Parker for Appellant Sam Birchmell, ready to proceed.
Thank you very much. We'll begin with the first case, C-240352, Costanzo versus City of Norwood. Because this is an original action, both parties will be given the opportunity to present both an original argument and a rebuttal, so each of you can reserve time. The attorney for Mr. or Ms. Costanza, if you would like to come forward.
Thank you, Your Honor.
And Mr. Thomas, would you like to reserve time for rebuttal?
I will reserve 12 minutes for rebuttal.
All right, give me just one moment to set up my timer here. And you may proceed when you're ready.
Thank you, Your Honor. It's good to be back in my favorite crucible. The issues that boil down from the motions on cross for summary judgment, Norwood contends that Tina has not met her burden, her trifold burden, in any respect, and they contend that Tina has missed her statute of limitations. Both arguments lack merit. We agree on the test that Tina must show by clear and convincing evidence that she has a clear right to relief. Second, that the Norwood has a clear legal obligation to provide that relief. And third, that she has a lack of an adequate remedy. The first element is shown by the taking. The only defense that Norwood establishes or tries to establish in this regard is the notion that Tina needs a surveyor to determine that the pipe is in her front
Counsel,
yard.
do you agree that it's your burden to establish the taking?
Yes, Your Honor.
And can you walk me through the evidence that establishes the taking?
Your Honor, the Norwood has installed a storm sewer system that begins on Tina's property in her front yard.
And where is the evidence that you contend demonstrates that the sewer equipment is on her property?
It's shown in the photographs, Your Honor, and in the documentation that shows where the property line is, her property line.
Are those photographs the ones in the complaint?
They're in the petition. They are in the affidavit that's supported by the affidavit of Ms. Costanzo. The Norwood filed the complaint that was filed in Hamilton County as well. That's in there. Norwood is also.
So it's your position, I just want to be really clear on
Certainly.
exactly what the evidence is. So it's your position that Norwood's complaint in the common pleas action is in front of us, that that's a part of our record in this
Those
action?
facts are in the record in this case as well, that Norwood introduced them. We have no objection to that being introduced. But the taking, that, to me, I find it a little bit.
And I apologize for all the questions, I just want to make sure we're
No,
clear.
that's-
So is it your position that the physical equipment is on Ms. Costanzo's property, that water intrudes her property, or both? Do both of those things constitute the taking?
Both do, because the sewer water system is not entirely on Tina's property. It starts on Tina's property, goes about 30 feet to a manhole that has some type of reservoir in it, and then piping goes to the adjacent property on which Norwood has an easement, and then it exits onto a third property behind and downhill from Tina's neighbor.
And where specifically in this record would I look for the evidence to establish what you've just described in terms of the location of the physical equipment?
It's set forth in the words, in the photographs. The photograph of the excerpt from the county auditor website shows the location of the property line, and from using that in conjunction with the photographs, you can see not only where the pipe is, but where the damages have occurred, the scarps and the concrete falling away from the established swimming pool in Tina's backyard, the patio on the adjacent neighbors falling.
Right,
falling
we've seen
down.
the damage, but I wanted to focus specifically on the equipment itself, and you've answered my question, and your
Thank you,
3
Rhonda.
minutes are up. Thank you very much.
And I do have a question on those questions. You discussed that there's an easement that's part of the piping, that the piping runs through these properties pursuant, at least a portion of it pursuant to an easement.
The city has a 15-foot wide easement that is entirely on Tina's neighbor's property that embraces some of the underground piping.
Where in the record would I find that easement?
Paragraph 14 of the city's answer admits the location of that easement. They've attached a document from 1946, I believe is Exhibit A, that shows that easement in the language of a property description.
Okay. And the discharge there's a place that the water discharges.
Correct, Your Honor?
Okay. Is there an easement associated with the location of the discharge of the water?
I do not know whether the easement goes that far, Your Honor. It's on a different parcel.
Okay. Thank you.
Thank you, Your Honor. Just for the clarification, can I know how much time I have now?
Yes, you have your full 12 minutes.
Thank you, Judge.
Thank you.
May it please court, Scott Solomon.
Yes,
I
and
have-
how much time would you like to reserve?
Your Honor, I'd like to reserve 4 minutes for rebuttal, please.
All right.
As Attorney Thomas did talk about, we're here today. They filed an original action before this court for petition for writ of mandamus with respect to attempting to compel the city of Norwood to institute appropriation proceedings under RC Chapter 163. He quickly went through the elements, which all need to be established by clear and convincing evidence.
Counsel, can you help flesh out this record for us? So it seems to me that there's a gap in the documentation that both of you have submitted between what occurred in 2019 and then what occurred in 2023 with the filing of the common pleas action. What transpired between the October 2019 communication from Mr. Thomas and the filing of the 2023 action in common pleas court?
As far as actions on behalf of the city of Norwood,
Or anything, or anyone? What happened in that time period?
I think there was communications back and forth, obviously, between the parties. And I believe at one point, there was an agreement to have a geological survey or testing done. And that would have been it. And that was kind
And
of.
is that what's attached to Ms. Costanzo's affidavit as Exhibit 5?
That's correct, Your Honor.
All right, so that document in some regard was produced by the parties or agreed to by the parties?
I think it was produced by a party, and I don't know, I represent City of Norwood, I'm not the law director. But I understand, I think the City of Norwood may have paid for that and obtained that.
All right.
And I
but-
think that doesn't really talk about the cause of anything, it just talks more about the fixing of, or potential fixing of the issues.
And to that point, has Norwood, because I think the heart of the question is, was there any actions on Norwood's part to remedy any of the issues that were being?
No, they haven't taken any action since, it looks like July and I think they retained for development to go ahead and resolve the issues that were occurring. I think the last action they took was in July of 2019.
Okay. So one of the things that you assert is statute of limitations having run with the 4 years. The counter to that is this continuous violation doctrine. Can you please articulate for me why you would believe that that does not apply here?
Well, I think there's no dispute that, it's unrefuted that the takings claim is governed by a 4-year statute, correct, under 2305.09E. And in determining, for it to be told, there has to be, he's asserted the continuous violation doctrine, which is only applicable in instances where there have been additional actions taken. In this instance, it would be on behalf of the city of Norwood. And there hasn't been any additional, the alleged,
But I think as I understand the argument, is that the continual discharging and infiltration of the water is the continuous action.
but that isn't that an action as defined in the Donor versus Zodi case. It has to be in that case, the entity was causing the flooding that was occurring again and again and again. In this case, the last time the city of Norwood would have taken any action would have been in 2019, July of 2019. And the fact that that was the last action taken, there wasn't any actions that they would have taken.
And that's where I'm hung up in, is the causation. So in the Donor case, the other, the respondent there was causing it and was continuously causing.
They were
the flooding.
intentionally flooding the area that was
Okay.
causing that damage. And this wasn't just a one-time, it wasn't like they put in a sewer. There's been other cases where there has been a sewer put in, and that
Okay.
is more of a permanent trespass. As this court in Davis versus Allen, 2002, Westlaw 63560, this court has defined a permanent trespass as occurring when the defendant's tortious act has been fully accomplished, but the injury to the plaintiff's estate from that act persists in the absence of further conduct by the defendant. And that's exactly what's happening here. The alleged tortious act would have been in July of 2019 when we took the last action. And just because it continues to flood because of that act, there's been no further contact. There's been an
So
absence
in
of
the
further
case that
contact.
you're citing, was the issue the installation, or was there a continuous action that occurred because of the installation?
It was the installation. And in
Because
that-
here, there's two things being asserted. One is the installation, and the other one is the continuous action that the property is enduring pursuant to the installation.
Well, and I would argue that there is no continuous action, because just because you go in and take a final act in 2019 and that may or may not cause the property to flood again and again, the last act you took was in 2019. That is the last act.
Do we have any evidence before us that this property is continuing to flood again and again and again?
No.
Is that fleshed out in this particular record?
I think there's a complete lack of evidence, quite frankly, with respect to the burden that petitioner has here. I think I've addressed that with the motion to strike. I think.
Counsel, I noticed that the images that were sent to the city in October of 2019 for the damage that was caused to Ms. Costanzo's property are the same images that appear in the petition. Do we have any evidence before us that there has been any further damage to Ms. Costanzo's property since 2019?
Not that I'm aware of.
And is there a reason why the city of Norwood did not repair that damage in 2019 on this record?
They don't believe that they don't believe that they're the cause of it. I mean, this is an area, and even as you'll acknowledge in the report, obviously, since, the land makeup of Cincinnati, this is a house that's built on a hill. They installed an in-ground pool on that hill. That would cause additional weight. There's other factors there's never been any determination that the city of Norwood and this alleged sewer, which discharges on a different property, has caused the actual.
Do we actually know that? I realize that both of you may know the factual, true answers to the questions we're asking, but I'm very focused on exactly what's been presented to our court and what we can document in the evidence. Do we actually know, based on this record and what is in front of this court, where this sewer equipment is located?
No, Your Honor. I would say that it's our belief that we're within the easement, that the sewer rests within the easement on the neighbor's property, not on Ms. Costanza's property.
And how would we know that? What would direct our attention in the evidence that's been submitted to the court as to where the piping is located?
I would just, obviously, there's no survey, so I don't think we do know. And there's nothing specific to say as much. What we do know is that it's been there for, at a minimum, 2019. Nothing's happened since 2019, which is outside the 4-year statute of limitations. I will submit that manhole, that sewer, that has been there probably since the early, I think 1946 was when the easement was obtained. Shortly thereafter, I think that sewer's been in place for quite some time.
And my understanding is that there's the image of the black pipe that is dumping.
That is not on the property. That is on, I think, an adjacent property. It's not on petitioner's property.
And how do we know that? What would tell us that?
And at this point, there's been nothing that would attest to that, I don't think. I think that's the big issue here is the fact that they've got to demonstrate that there is an appropriation. There's no evidence that is in the record to find that.
There's no
Let alone
evidence,
by-
there's no evidence that the manhole or the pipe's on her property, is that what you're saying?
I would say that, and you argue the other way too, but the reality is the clear and convincing, certainly that falls well short of that, of what is required. There's not enough evidence even by preponderance, in my opinion. So I think the burden, even assuming this was within the statute of limitations, they still would fall short because they can't establish the fact that they have a clear right, that we have a clear duty, and they didn't even address the fact that there's no other adequate remedy. That wasn't even addressed in their summary judgment motion.
So Norwood tried to fix it in 2019?
I think steps were taken to, I think 2017, steps were taken to address the sewer, water sewer, and then also in 2019 as well.
Even
So
though
what else?
Norwood is claiming that it's not their fault, or they were just gonna fix it just to be nice?
Well, I think they did fix it. The water now doesn't, it was pooling, and so they have addressed that issue. It's
Oh, so
now-
they
it's
fixed-
dumping the- it's
they
fixed.
fixed the
It's their fix.
pooling
It's been
issue.
designed to dump the water past the property onto another property.
Okay, so they fixed part of the problem, I guess?
Well,
That they
there were
thought was-
sinkholes
That they
were-
thought was their
There was,
issue.
initially in 2017, my understanding is the fact that there was holes that had, and they addressed those, they fixed those to stop the sinkholes. And then in 2019, there was additional, I think, more water coming. So that was pooling in the properties, in the street, so they addressed that to disperse that as well.
And counsel, can you address your motion to strike?
That is essentially with respect to that, the fact that the pictures that are submitted, there's a lot of, the only evidence in this record that has been provided by this petitioner is just her lone affidavit. And in doing so, she attaches the 6 exhibits. Plaintiff's petitioner counsel makes reference to pictures in the petition. Those aren't even addressed in her affidavit. We don't know who took those. We assume she took those. We don't, they don't, there's trees in some pictures, there's not tree in other pictures. We don't know the timing of this. We don't know any of this stuff. There's also,
So is it your position that the petition is in or out in terms of being evidence before the court?
I think there is, now, when it was filed initially, it wasn't verified. It wasn't verified until her affidavit says that I think some of the paragraphs, the facts that she alleges are true, but then there's nothing that addresses the pictures are unauthenticated, the exhibits are unauthenticated, she doesn't have any professional knowledge. With respect to this, there's no survey. I think she talks about the alleged damage to the value of her home, which really doesn't come into play in this issue, which as to the elements that are required. I think any opinion she would give that is an expert opinion, the case law holds that survey determining boundaries of a property are outside the knowledge of a layperson, and that's simply what she is. She provides no credentials with respect to any type of alleged knowledge of her
However,
expertise.
within the packet that she provides, she does provide, well, she does talk about damages in the context of the loss of the value of the property. She also includes estimates for engineering work and correction work, which would go to damages. And in Exhibit 6, it seems to me, with the Cole Engineering Solutions memorandum, that seemed to go to causation.
Well, I would say that, but still, she's not the custodian of that. She just received those documents. She doesn't even say that they're true and accurate, for instance. So I think there's a lot of issues with the way, this court, with respect to original actions, the rule is the following: the fact that, excuse me for a second. She doesn't have personal knowledge, which must be gained through firsthand observation of experience. She certainly can't attest to that. With respect to original actions, Local 33B says, affidavit shall be based on personal knowledge, setting forth facts admissible in evidence, and showing affirmatively that the affiant is competent to testify to all matters stated in the affidavit. Sworn or certified copies of all papers or parts of papers referred to in an affidavit shall be attached. She received these, and she doesn't even say she received the last Exhibit 5 and 6. She just attaches them. It's improper evidence to be considered with respect to, obviously, this original action, as well as 56E. It's not proper evidence, is our position.
Your 12 minutes have expired. Thank you.
Thank you, Your Honor.
I have to begin with the notion that I heard today for the first time in 5 years that the pipe is entirely within the easement. It is, I can't believe that factually we have that disagreement. We ought to be able to agree on where this pipe is. Tina says in her affidavit that the stuff I said in my petition is true, and the way the pictures are shown, say the picture reflects these facts. So if we look, for example, at the photograph where the storm sewer begins on photograph number 6, and we see it's directly in front of Tina's house, she's entitled to say that that's on her property. She doesn't have to be a surveyor. Norwood citation to Dysart that says experts have to state their credentials, that's all well and good. But an owner of property is entitled to say where the boundaries of her property is and what the value of her property is. That's been established in Ohio for decades. So I just wanted to get that point clear. With regard to the statute of limitations, I'll say it succinctly. Every case that Norwood cites on its statute of limitations for its permanence argument falls into one of two categories. Either it's before donor, which was decided by the Ohio Supreme Court in 2011, or it's decided in a completely different context that doesn't discuss donor, like the Sims Township case, Loveland Sims Township, talking about tax increment foundations or such as that. Nothing to do with our situation. I have never in my career cited a case for 2 pages and risked boring the court with that lengthy discussion. I did it here because donor couldn't be on all fours with our situation.
Counsel, what about the argument that the Ohio Department of Natural Resources in donor was continually controlling the lake levels?
just as Norwood controls this sewer system.
What decision have they made between 2019 and now with regard to the sewer? What are they doing to control it?
That's another thing that troubles me, that Norwood is not willing to acknowledge that in 2021, they commissioned a detailed survey using inclinometers, pipes that go into the ground that measure the transverse movement of the earth, and had that report issued in July of
And
2021.
where is that in our factual record? I noticed that
It's in
as a,
Exhibit 5, Your Honor, of
All right.
Tina's affidavit.
do we have the link? I know that's an allegation that's made in the petition, that occurred in June, I believe, of 2021. That's alleged in the petition. And then I know you've attached Exhibit 5. Do we have anything that draws the link between Exhibit 5 being the geotechnical report that's referenced in the petition?
I'm not sure the express answer to that, what that is, but it illustrates the answer to the court's question, what happened between 2019 and 2023? Well, this is what happened. And the experts made recommendations to Norwood. And Tina, like a good citizen, is waiting for Norwood to take action, voluntarily, cooperatively, informally, for both her benefit and the neighbor's benefit, and the downhill property's benefit, and nothing was done. There's
So from
clear,
your
specific-
perspective, the answer to the, like, what happened in between 2019 and 2023 is that there was some ongoing negotiation and conversation?
Yes, and this is a situation where Tina's powerless to do anything on her own. They've got the easement, they've got the piping system.
So just to make sure that we understand the record, we're to gather that just from the date of this geotechnical report that's attached, or I can't
Well, the
remember, does she talk about this ongoing discussion, or that she was waiting on this report, them to do something because of the report, or do we just have the report?
Well, Norwood has provided that information, and they've submitted in their evidence the affidavit of Mr. Gary, the law director, and he quotes or includes correspondence that I sent to him, and I believe there's emails that talk about this effort, and the geotechnical report itself gives a little bit of the background and the history. So I think those are the three things that were going on, and it's
So it's evidence that was submitted by Norwood that we would look to kind of see what was happening after
very
2019?
very much so in that regard, Your Honor. So I just want to, I don't want to belabor the
Let me go
statute of
back to
limitations.
donor. It seems to me that the issue in donor and this case is control, the term control, and how does that apply to this case? So while in donor, the control was much more evident, how would you articulate the city of Norwood's control?
Well, let me first point to misrepresentation by Norwood orally here today. Counsel suggested that in donor, they were continually flooding. They made decisions that flooded the property. Actually, the opposite is true. They stopped doing anything. They said, we're not going to do anything anymore. But they still had the control. They had the power to do things. And that's exactly what we have here. Inaction by the party, the sole party that has power to do something. That's why donor's applicable. And it has nothing.
Would you say that the easement that they have is part of the control?
Absolutely, Your Honor. It's half of the line. The line the portion of the line that's on 2503 Mountain View. So the donor case also has an interesting flavor that shows a bit of the two-faced argument that Norwood is making here. In I think it's on page 9 of their memorandum contra our motion, they talk about in Donor, the tortious conduct occurred on adjacent land. And then they try to fabricate the idea that if it happens on the moving party's land, that some kind of different test applies. But note that here, they're arguing for the purposes of the taking that the pipe isn't on Tina's property. But they're arguing for statute of limitations purposes, oh, it's on Tina's property. And that's why it's a permanent, because she would have had notice. But Donor doesn't even say those things. It's a misinterpretation.
But I think that goes to the reality that, as I understand your position, there's two takings. One is the installation of the sewer section that was placed in the front yard, in the front part of the home. The second was, at that time, the piping that was put into place that seems to go across more than one property, but then discharges, and when the water discharges, then that water itself is creating ultimately a damage.
And how it's creating, that's not for Tina to say, but Tina, as the owner, as the person who's lived there since 1996, with her own eyes and her powers of observation, can testify within Rule 701 about the effects. And although I'm very sensitive to after this because of this kinds of arguments, but when it happens and the consequence occurs, and then it happens again, and then there's sinkholes, and then it happens again, and then concrete. You know, one of the questions was what's changed between 2017 and 2019? How are the pictures different? If you look at the concrete steps,
2019 and now.
well, 2019 and now, if you look at the photograph of the concrete steps next to the pool, they were about 8 inches off. And then in the later pictures, it's like 1.5 feet off.
Right.
I mean, it's continual creep, Your Honor.
Well, that,
Creep being a technical,
well, we can't just
term that I've
assume
learned.
that, counsel. We can't just assume that. So I did see the pictures. I've reviewed them carefully. And I saw exactly what you're talking about. So, you know, that in June, there was one status. June of 2019, there was one status. And then October of 2019, it was significantly worse. I saw that. But I didn't see any updated pictures of any time after October of 2019. Where can we go in the record to see what a more current status of the property would be?
Your Honor, if that's a shortcoming on my part in the presentation about the failure to have photographs leading up to the filing of the petition, I would urge the court to be mindful that I need to show damage. The amount of damage will be shown at the appropriation hearing, at the hearing that Norwood should be ordered to conduct, where the value of the how much the property's value has been diminished by the city's actions and inactions. And
Well,
so-
one thing they're claiming is that there's been no control, no action taken, no exertion of responsibility with respect to this property in a statute of limitations posture since December of 2019. And so my questions are in that domain.
And I would first submit that it's their burden to illustrate that the statute of limitations is in effect. Their case law is ineffectual. Their case law is inapposite. Their case law is old and has no precedential value. And I just find these suggestions, they're just, quite frankly, I assume that they were basic facts that we'd be arguing legal points, not these fundamental issues. And for the city to ignore the many thousands of dollars that they spent in 2021 to pay these geotechnical folks pursuant to an ordinance, and just to simply ignore that and supply 3 affidavits saying we haven't done anything since December 31st, 2019 is a bit disingenuous. As disingenuous as saying the pipe is entirely within our easement.
Well, would that have been provable by you? The fact that they had paid for the 2021 report, would that have been provable by you?
Tina was not privy to those agreements. We supplied the report that was generated, no doubt not generated pro bono, but I know from experience how much these firms charge for their rarefied expertise in these kinds of issues. Consequently, I believe that Tina has met her burden in that regard. And finally, with regard to the burden, the lack of a remedy at law, the only thing that Norwood says with regard to a lack of remedy is a circular argument that because she hasn't shown a taking, she can't show a remedy. It's clear the remedy has to be complete and speedy, and Tina's been waiting 4.5 years, hasn't gotten anything. This is the only avenue for her to get some type of relief for the diminished value of her home and her land.
Thank you.
Thank you, Your Honors. Pleasure.
Your Honors, I want to bring your attention to, our position is that this case is in opposite to donor, and it's more along the lines with the rationale set forth in State X-Ray Lee v. Village of Plain City, where they say donor, in that case, they found donor is distinguishable as it involved a continuing trespass by repeated flooding of the landowner's
Doesn't the
property.
sewer system belong to Norwood? I mean, there's no dispute that this is Norwood sewer.
Yes, and in that case, too, they said here,
So
however,
then how is it the case that Norwood isn't exercising control of it? I mean, no other entity would have control of the sewer, right?
well, in this case, the entity owned a sewer, too, and they say here, however, there is a permanent trespass as the sewers and other infrastructure were in place on the Lee's property as of 2006. So in that case, same thing. It were sewers that were at issue. In that case, they had direct and immediate notice of the presence of the sewers, and the sewers have remained in place with no further action by the village. That's exactly what's going on in this case. Those sewers have been in place at a minimum 2019. We've done nothing since, and they've been on notice. There's, in the unauthenticated pictures, there's people who are standing in ditches with the sewers. So she knew the sewers were on her property, if potentially. We still don't think that's the case, but there's no survey to demonstrate
You don't think
that.
that sewers are on her property?
I don't know. I don't think so, because it's been in place the whole time. Even before she bought the property, you can see a picture on the auditor's site from an old, this, you can see the head of the sewer in that lines up with, I think they're within the easement, I do.
But even if the sewer was on her property back in the 1940s, what I think I hear you saying is that the easement that allowed the city to put in this piping that now discharges water was not in place in the 1940s.
It wasn't in 1946, it was.
So that piping that discharges water has always been
There was piping that went through. They remedied the last 2019 fix is when they put potentially. Now, we don't know if the 2017 fix had the black pipe on the adjacent property, if that was in place in 2017 or 2019, that's unknown to us. Or if it was even there beforehand. There's no evidence.
My understanding of what I'm going to characterize as limited evidence in this case that both parties have submitted is that there was some issue with the functioning of the sewer system in 2017 that caused some flooding. And I believe Norwood admitted that in its 2019
Yes.
ordinance.
They found holes. They replaced parts of the sewer to address those sinkholes, and they believe they have been addressed.
And after the 2019 ordinance was passed and the repair was conducted, there was still an issue from Ms. Costanza's perspective with her property. And she and her counsel began to initiate conversations with Norwood about additional repairs to both the sewer system and her property that were necessary at that time. And from my perspective, the record then goes dark as to what occurred, which is why I asked.
And I disagree with the position of petitioner that the fact that we may have took some investigative geological technical survey, that's not tortious action. That's what's required, is continuous tortious action. That was just, okay, we'll take a look at it and see, what they determine, what they find.
It's an explanation for why they didn't do anything, right? Because they were expecting Norwood to comply with the recommendations in that report?
I don't know that that was ever agreed upon.
I know it wasn't agreed upon, but clearly Norwood admits that it
And
was.
I don't know if they
it
tried to
got this
find-
report done. The report gave suggestions on how to fix things.
Yes.
And so she was waiting for that to happen, we can presume.
I wouldn't,
You wouldn't go that far.
I wouldn't go that far. I don't know if they were just doing investigative research, if they were trying to find the cause. You know, even in the Exhibit 6, the conclusions and recommendations section, it says, Northern Kentucky, Greater Cincinnati area is highly prone to landslides due to the geological typical of the, to the region. They say creeps can be exacerbated when any of the following occurs, including weight is added on the hills, on the upside hill, i.e. putting in a pool. Soil is excavated on the downhill side, i.e. putting in an underground, an in-ground pool. And also with respect to the continuous violations doctrine, this court has held in the Board of Education versus Loveland City School District versus Board of Trustees of Sims Township that courts have been reluctant to expand the continuous violation doctrine beyond the original context in which it was applied. And I think similar to the Lee versus Village of Plain City, no further information was necessary for the Lees to determine where the storm sewer was located. No additional action was taken by the city.
And your time has concluded.
Thank you, Your Honors. Appreciate it.
Thank you. Thank you both for your arguments. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day. The next case is C-240284 Wilson versus CSX Transportation. Mr. Joyce, you may come forward when you're ready. Would you like to reserve time for rebuttal?
I would like to reserve 3 minutes for rebuttal, please.
You may.
Good
And you may
morning,
begin when you're
ladies.
ready.
This is an FELA case, railroad case. Judge Goring granted summary judgment in Mr. Wilson's case, and one of the most significant problems that we have with the issue is this was a 3-count complaint. 1 count was cumulative trauma disorder. 1 count was for specific traumatic injury in November of 2012, and a 3rd count was for a specific traumatic injury in January 2013. Nowhere in Judge Goring's opinion does he even discuss the cumulative trauma count, the count 1. And that's a problem because that is a viable claim under the FELA. 2 cases in the Sixth Circuit that confirm this are Aparicio and Hardiman, both of which say cumulative trauma disorder claims, things that happen over time, are compensable under the FELA. The fact that Judge Goring didn't even look at it, he focuses, as you read his 5-page opinion, he focuses on the 2 specific incidents that we talk about. That in and of itself is a reason why this needs to go back to the trial court.
But with regard to that claim, what did you point to as the negligent conduct?
Sure. The theory of liability, there's 3 theories of liability as to the cumulative trauma claim, 2 of which are, 1 has to do with the fact that Mr. Wilson was provided with a boom truck and the boom didn't work. The boom is that thing you see where you lift heavy equipment off of the back of a truck. It's kind of like a little crane that's kind of attached to a pickup truck. Boom trucks on the railroad are much bigger than that, but the point is, the whole purpose of the boom is to take the heavy equipment off the truck so the individual doesn't have to get up in the truck and do it. When you give the employee a boom to use, it should be working. In Mr. Wilson's deposition, he repeatedly complains to supervision about the need for the fact that the boom is not working. Finally just gives up on it because they don't respond. Second theory of liability is when you're assigned a welding helper, primarily he was a welder for most of his career from 1980 until about 2013. He's specifically assigned to a welder helper, and the last 10 years of his career, Teddy Berggraf is the person he identifies, doesn't do his job, okay? Not having sufficient manpower is a theory of liability under the FELA, according to
Counsel,
Blair.
isn't there a significant body of case law that suggests that help, additional workers are not required?
There is the U.S. Supreme Court in Blair versus the B&O that says insufficient manpower is a viable theory of liability under the FELA. Plenty of case law that he cites in the trial court cases from the railroad. Blair is the critical case under the U.S. Supreme Court that says insufficient manpower is a viable theory. So when Mr. Wilson doesn't get the help of Mr. Berggraf, think about it, the welder helper is supposed to help him take all the equipment off the truck.
And is that insufficient manpower geared towards keeping people safe, or is it geared towards getting the job done, or are those the same thing?
Primarily, it's towards keeping people safe, okay? So when Mr. Berggraf doesn't do his job, Mr. Wilson repeatedly complains to supervision, Teddy's not doing his job. I need help. I'm doing it by myself. Both of those theories of liability, the boom or lack of a boom that works and lack of a helper that helps, are both viable theories of liability under the FELA that the judge ignored.
Did Mr. Wilson point to any specific incidents with regard to when the other employee wasn't helping him, or was this just in general the guy wasn't helping?
What he says, over the last 10 years of his career, half the time Teddy Berggraf was his helper, and he's not, there is no incident. In the cumulative trauma case, we're basically alleging over the course of his career, he didn't get the help, he didn't get a boom that worked. The last theory of liability as to the cumulative trauma case is from our liability expert, Peter Kelly. He has theories of liability, one of which is the railroad does not acknowledge these cumulative trauma injuries. They completely ignore them, and when Mr. Kelly looked at their safety program, he opines that it may be good for specific traumatic injuries, but it's lacking, inadequate for purposes of the railroad training their employees like Mr. Wilson on what to do to protect yourself from cumulative trauma disorder injuries. Those are the three theories of liability, all of which are viable under the FELA, all of which Judge Goring never even discussed, let alone found a reason or explanation why they didn't apply. The second issue with
So
cumulative...
just on that one, you're saying that it should be remanded back to the trial court, or is this something that we
Well,
decide at this level?
Well, the point is, there's nothing in the record that Judge Goring even considered the cumulative trauma count. What he did was he spent his opinion talking about the two incidents. And even that is reversible error, because when you look at what he did, he's weighing evidence, he's drawing inferences, he's assessing credibility as you look at the comments that he makes in his opinion, and that's for the two counts that have to do with specific injuries where he hurt his knee.
No, but just back to my question, are you saying that this court should remand it back, or do you think that we can decide that at this level on the cumulative trauma?
I think it should be remanded back solely for that reason alone, but separate and apart from that, it should be sent back to the court, reversed and remanded, because the purpose of summary judgment is not for you to weigh evidence, draw inferences, and assess credibility. One of the things that Judge Goring says in his opinion about the incidents are, there is no evidence in the record to suggest the injury happened during work. Mr. Wilson's sworn deposition testimony is evidence in the record. Yeah, there's a big issue here, because he lied to his doctors and didn't report these injuries to the railroad, because there's the written rules and the unwritten rules. I've been doing this for FELA for 37 years, and the unwritten rules are if you get injured, you get fired, okay? That's just the way it is. They do not accept cumulative trauma injuries to begin with. But here's the judge looking at, one of the things he says, well, look, he's made at least 5 reports of injuries and received cash settlements. Therefore, I don't think he should have explained that.
Wasn't there a 16-year gap between his last injury report in 1996 and these injuries?
There is a gap.
And how do we weigh that?
The railroads historically look at trauma claims. That field's been around since 1908. Specific trauma claims have always been what they dealt with, okay? What really upset the railroads was when people started bringing cumulative trauma claims. It started with carpal tunnel syndrome, same analogy as a worn-out back, worn-out knees, worn-out neck. The point here, though, is the railroads absolutely hate these claims, because their position is it's not work-related, because you've got degenerative disc disease or degenerative joint disease. We're not here to say that the railroad was negligent in causing those injuries, but the FELA standard of causation is very liberal. It is if the railroad's negligence in whole or in part caused, contributed to, or aggravated a condition, it's compensable. So what our two doctors give us, and Dr. Dr. Larkin did a knee replacement, and Dr. Larkin says in an affidavit submitted to the judge, in my opinion, Mr. Wilson's excessive physical labor at the railroad aggravated and worsened his degenerative joint disease in his knee, requiring a replacement. Dr. Kakalaputi, who did his cervical fusion surgery, says excessive physical labor at the railroad aggravated and worsened his degenerative joint disease in his, degenerative disc disease in his neck. That's causation under the FELA. The point is, we have all the elements here. It's just what the judge did here, and it's so glaring when you look at it, as you see. We know under summary judgment, you're not supposed to weigh evidence. That's the jury's function. You're
Well,
not
let's
supposed
put-
to assess credibility.
Let's
That's
put
a
that
jury.
aside and let's say we agree with you that
Right.
the judge did an improper credibility
Right.
assessment. If we look at the claim for the 11/20/2012 incident,
Right.
can you talk about what, so this was the incident where he tripped and fell over some
Joint bars in the back
joint
of the truck.
bars because he wasn't provided with a
Rack on
a
the front of the
rack.
truck. Right.
So how is that negligent on behalf of the railroad?
Well, the fact of the matter is, the joint bars, the truck he had did not have the rack for the joint bars. Therefore, you know, if they didn't have a rack for joint bars, then there's no negligence there. But the fact that they have one, the purpose of the rack is to keep those joint bars from just laying in the truck, creating a tripping hazard. Okay, so it's
So
a
do we
theory.
know that from the record that the purpose of the rack is for those safety reasons?
Sure, Mr. Wilson testifies under oath at his deposition that some of the trucks, which I didn't have, had a rack to put the joint bars on, and therefore, they wouldn't have been in the back of the truck, creating a tripping hazard, okay? So we have a theory of liability there. Candidly, this case, to me, the incidents are not as important. They're just examples of some of the things he dealt with. I think the heart of this case, because we're dealing with a knee replacement and a multi-level surgical fusion, is the CTD case. Though candidly, I'll admit the weakness in the two trauma cases, November of 2012 and January 2013, is the causation angle. Because that's not really what if you think about it for a minute, Dr. Larkin and Dr. Kakalaputi are relying upon him saying, I got hurt at home. So those are the weaker things here, and maybe you don't hear this much from appellants. The point here, though, is I think the causation angle, I agree, is the weakest element of the two trauma cases. But the point here, though, is when you're
Well,
dealing...
doesn't he know, I mean, when you're talking about a specific injury,
Right.
somebody trips over and contorts their
Right.
knee and
Sure.
ouch, right? I mean, doesn't the person themselves know the cause?
Well,
An injury like that?
Well, sure. I mean, if you don't have any knee pain, you trip over a joint bar and you have knee pain, it's pretty simple to say the knee pain came from the tripping incident, okay? Similarly, when he says he gets hurt in a hole, they had removed a tie, created a hole. When he hurts his knee again in January of 2013 in a hole and he immediately experienced knee pain, you know, it's not rocket science to figure out that's where they came from.
Right, but I think the issue here with specifically to the tripping incident is, you know, whether it's because of the lack of the safety rack and what the purpose of the safety rack is.
Sure.
So while the record establishes the lack of the safety rack and other trucks having it, even being retrofitted with
Right.
it, the purpose of the rack is not, I'm not able to glean that from the record.
Well, I mean, again, this is not rocket science. The purpose of the rack is to put it in a place in the truck so it does not just get thrown in the back of the truck.
Do we
You know,
just, we make that an inference?
You can make that.
That it's,
inference,
the purpose of the racks were for safety's sake?
Absolutely. And, you know, the other issue
How do we
is,
know that, for example, the purpose of the rack was not to enable more items to fit in the back of the truck so that it was more efficient to cart around things?
because Mr. Wilson testified in his depth specifically that the rack was to hold joint bars, not other pieces of equipment. There were other things on the truck to hold other pieces of equipment. But the point here is...
So we would look to Mr. Wilson's testimony.
Look at Mr.
for
Wilson's depth. He talks about the joint rack and what the purpose of the joint rack is on the truck. But ultimately, at the end of
But
the
he
day...
doesn't talk about it in the nature of safety.
No, he's talking about it as an
It could be for
employee.
tidiness, it could be for many other reasons, and there's also no rules that were submitted as to, you know, the railroad use of the safety rack or the requirement of the safety rack or any of that nature.
Right. It's not, I don't have a liability expert saying, here's the purpose of the rack, that Mr. Kelly does not say that. The ultimate reason we're here, though, is breach of duty, negligence is a fact question under the FELA. It's not something where the court should be assessing credibility, weighing evidence, drawing inferences, and ruling as a matter of law. No jury can find negligence here. If we came in here like Mr. Carnes suggests, we're just saying he was doing his job was heavy, so what, that's no big deal, there's no negligence. We have viable theories of liability supported by case law under the FELA that say these are the types of things. Now, a jury may say, no big deal. Who cares about the joint rack? It's Mr. Wilson's fault for putting the joint bars in to begin with. FELA is a pure
I
comparative
think they can
negligence
say that it
statute.
was open and obvious, and the joint bar was there, and it wasn't hidden, and, you know, he tripped on something that,
Was open and obvious.
was
He
open
put
and
it in there,
obvious.
by
It was
the way.
there.
One thing about FELA that's different than Ohio law is it's a pure comparative negligence statute. Mr. Wilson could be more negligent than the railroad and still recover under the FELA. He could be 99% negligent, still recover because the railroad's 1% negligent. Now, obviously, his damages get reduced, but the point here is that Mr. Carnes is arguing in his papers, it's his own fault. He put him in there, and he stepped on him, he got hurt. That's something for a jury to decide. Contributory negligence or comparative negligence is also a fact question for the jury. Judge Goring usurped the jury's role in this case, completely ignored the primary theory of liability, which is the reason why the guy came off and had these 2 major surgeries and left the railroad early. And I think that in this case here, no reasonable juror could understand these theories of liability. A broken boom.
Can you explain the theory of liability for the January 24, 2013 incident?
Sure. So somebody in the track department takes out a tie, they're the wooden ties, and that creates a hole. Mr. Wilson's job as a welder is to get in there and weld the rail. Well, he's got to deal with this hole because that's where he's doing his welding. Our theory of liability in that one has to do with pads, knee pads, okay? And they have them, they're out there. He testifies as a dep under oath, never once did I ever get a knee pad from the railroad, okay? So we have a viable theory of liability there. If he has a knee pad in there, he doesn't twist his knee, okay? And he's in a hole, which is already a dangerous condition.
So is there evidence that he asked for knee pads and they said no, or?
He testifies in his dep that never once did I get a knee pad on the railroad. Knee pads existed on the railroad. He saw other people using them, okay? That's the evidence.
But was there's no information that he requested knee pads and the railroad wouldn't provide?
I can't recall that from the deposition transcript off the top of my head, so I don't want to answer something I don't know the answer to. But the point here, these cases, the purpose of the FELA is to give the jury an opportunity to assess these
but I
cases.
think ultimately, I mean, as I read Goring's entry, it all pivots on presentation of evidence of negligence.
Right.
Negligence
He
on the part
basically
of the
says, I
railroad.
reviewed the record and I don't see any negligence, therefore I find in favor of the railroad. You know, it's not so clear-cut that way. Jurors are supposed to do these things, not judges. If I came in here and I said he was doing his job, he got hurt, it's work-related, I want money, toss the case. It deserves to be tossed. Just like I'm arguing to you these theories of liability that are viable under the FELA, I'm going to argue the same thing to the jury if this court reverses and allows me to do so. So it's not that we came in here and said we don't have any theory, oh, well, he's just working hard. These are real theories.
I'm trying to understand why the failure to give knee pads when, like, there's no information that he asked for them and didn't get them, how that's a theory of liability of negligence on behalf of the railroad.
Because he talks about the fact that there were knee pads and I never got any. What makes liability under the FELA is when you have a problem, you complain and it falls on deaf ear. For example.
Well, that's my question.
Yeah. So
Is there information in the record that he complained about not having these knee pads?
And I can't tell you off the top of my head whether there is or is not. But my point, though, is the complaints are what triggers liability. If you have a broken boom on your truck and you don't tell anybody about it, that's on you. If you have a broken boom on your truck and you repeatedly tell your supervisors it's broken, I need a boom that works because I have to do all this stuff manually, that is negligence under the FELA.
What about the rack?
The
Was there
rack, again,
information-
is, I think the rack itself is also a weaker liability theory, okay? My focus here is the boom, a broken boom, a helper who doesn't help, and when you complain multiple times, I need a helper that helps, and they say, go pound sand, that is negligence under the FELA. And I've got a liability expert that says, he opines that the railroad failed to provide Mr. Wilson with a reasonably safe place to work, and Judge Goring just denies that. I mean, if I came in here and didn't have a liability expert, that's another issue. But these are 3 theories of liability that are viable, and the only way the judge could dismiss him is because he had to look at credibility. I don't believe Mr. Wilson. There's nothing in the record. Of course it's in the record. He testified under oath that he complained, and the reason he didn't put it in his medical records or tell his doctors is because he was going to get fired. We have a case here. It should get
Counsel,
sent
you're
back.
out of time, but I want to see if my colleagues have additional questions.
I have 3 more minutes if you guys want.
Thank you.
Thank you.
And counsel, the appellant went over by a few minutes, so I'm going to give you a few additional minutes to argue.
Thank you, Your Honor. May it please the court, James Carnes on behalf of CSX. I think I'm going to start first with the 2 traumatic claims. Counsel's here saying they're not the most pressing issue. He didn't respond to them in his reply brief. And he's stated up here that there wasn't sufficient evidence or that the court, relied on credibility determinations. Of course, the standard of review here is de novo. There'd be no reason to remand the case here because of that. This court can decide on the record whether or not summary judgment was appropriate, irrespective of what the court put in its.
Would you agree the judge was wrong to assess credibility in this case?
I would agree that.
Disbelieve him?
I would agree that the court referenced credibility determinations in the opinion. I don't think it matters for purposes of why we're here today.
Tell us why that doesn't matter.
Because it's de novo review and the record's in front of the court, and the court can determine on its own whether or not, based on this record, CSX is entitled to summary judgment. So whether
And
the
in
co-
doing that, we would not be making a credibility function.
Correct.
or
The court
determination.
does not have to make credibility determinations to grant summary judgment on either one of the traumatic claims. So the first traumatic claim involves the joint bars. And so his claim, as I understand it, is that some trucks had a special rack to store joint bars. Some trucks did not. He said sometimes, or on the date of the incident, his truck did not have a special rack to store these joint bars. So, again, under the FELA, we're not required to provide the best equipment or even the safest equipment. The only question is, was he provided a reasonably safe workplace?
Well, could a jury make an inference that other workers had a more safe work environment because they had these racks and therefore had a place to put these bars?
No, Your Honor, it wouldn't matter. I mean, our duty's not, maybe someone had a safer workplace, doesn't matter. The only issue before the court would be, was his workplace reasonably safe? Not whether there were safer methods, better equipment, more modern equipment. It's a joint rack, to the court's earlier points. There's no evidence in the record that it was there for safety issues or to prevent tripping hazards. There's no record.
Do you think that there has to be specific evidence in the record that it was there for safety or was there to prevent tripping? Or do you think that because there's no evidence whatsoever why they were there, we can infer that because the railroad did equip some trucks with these racks, we can infer that they were put there for safety reasons?
I think you can infer they were there to store joint bars, which is,
But what about for safety
I don't think you
purposes?
can infer that. I mean, there's no evidence in the record to infer that it's there for safety
But don't
reasons.
we look at the evidence in the light most favorable to the non-moving party?
Sure, but
And inferences.
Even if that were true, if it were there for safety issues, we're not required to provide the safest equipment or the best equipment. The question is what he was provided reasonably safe?
But isn't the comparison that you did provide some racks on some trucks and no rack on his truck, could that not be considered negligent action if it was in fact done for safety reasons?
No, Your Honor. It could show that maybe it's a safer piece of equipment, but that doesn't mean his piece of equipment was unsafe.
So then is it your position that the fact that there were these racks on other trucks, is that just irrelevant?
It is irrelevant, yes. It is irrelevant. The only issue is, was his job task, was his workplace reasonably safe at the time he was there? And so what happened with Mr. Wilson is, he took, they were stacking joint bars, or they were moving joint bars that would ultimately be removed in the back of a work truck. According to Mr. Wilson's own testimony, he, unlike every other worker, moves these bars into the back of the truck while he's working, and then climbs up onto the truck and stands on them as he's doing his job.
So couldn't a jury make the inference? I noticed that testimony that he said that everybody else like laid them on the ground or something.
Yes.
And that he put them in the truck itself. But couldn't a jury make an inference that they're a tripping hazard regardless of whether they're put on the ground or put in the truck?
No, Your Honor, I don't think they could, not to the point where it'd be negligent on the railroad. I mean, the bars, he's just moving material onto the ground, out of his way is where it should be. And then he would go on the truck, access whatever he needs to access. At the end of his workday, like everybody else, you would put the joint bars in the back of the truck when you're finished, and you would leave. So, I mean, potentially anything's a tripping hazard, but this material is supposed to be in a spot. He's in charge of moving that material. He's making the decisions there. This really isn't on CSX. I mean, CSX had no knowledge he was even doing this. I mean, there is a foreseeability element to an FELA claim, like any negligence claim, and CSX here had no knowledge of what he was doing. This wasn't caused by some breach of a duty from CSX. to Mr. Wilson. This was choices Mr. Wilson made as to how he put these in there. He intentionally stepped on them in order to access an oxygen tank that was in the back of the truck. There's just no negligence there on CSX's part. And then the next part of this, and counsel referenced this, is causation. There's been no evidence in this case that he suffered any injury as a result of the incident involving the joint bars.
Except for his testimony.
His testimony,
I mean, doesn't he say that he hurt himself because of the,
well, I would say he needs
Bars.
expert testimony to determine whether or not he injured himself. His injury here, according to the affidavits, is degenerative joint disease. So certainly if he fell and broke his arm and had some discrete injury like that, but I don't think he can diagnose himself with degenerative joint disease of the knee because he stepped on a joint bar. And so that, the record just doesn't support that. And I would note, I would also note, Your Honor, that Dr. Larkin, who they got the affidavit from, is the doctor who treated Mr. Wilson. And if he believed Mr. Wilson had an injury from either of these incidents, he could have put that in the affidavit and did not. I suspect the reason he did not is because his records don't show either one of these incidents because he lied to his doctor about what occurred. So we have no medical record showing he suffered an injury because of any workplace incident, no affidavit, no expert testimony. So, we don't think the record shows negligence. We don't think the record
it
shows.
would have to be some evidence of some sort of acute injury
Correct,
rather than a degenerative
Yes.
situation.
yes.
Okay.
Incident 2, when I say incident 2, I'm referring to the second incident. He removed a railroad tie. He's a welder. He was involved in kneeling, squatting, bending, according to their complaint. Said he had to do physical activity while stepping into a depression. That all may be true. That's not evidence of negligence. That's just his job duties. I heard counsel up here argue about knee pads and lack of knee pads. So, number one, I don't think he argued that in his brief, and if he did, I apologize and I missed it, but there's no evidence in this case that he was injured because of a lack of a knee pad. So again, I think, number one, you would have to have some evidence showing it's unsafe to do this job without a knee pad. Number two, I think you would have to show that him doing that job without a knee pad caused some injury. We don't have that here. Again, there's no causation. The expert affidavit from Dr. Larkin doesn't address that at all. There's really no negligence here. This is simply, I did my job, I bent down, I kneeled, I worked, and I felt some irritation in my knee. So there's just no evidence of negligence there, and no evidence of causation. And I would push back on what counsel said about complaints. I mean, evidence of complaints is not evidence of negligence that gets to a jury. I mean, that doesn't get him to a jury by just saying, I complained about something, they didn't respond to my complaint. I mean, this is a negligence action. He still has to establish.
Well, doesn't that go to the reasonably safe work environment? I mean, if you have an employee who's saying, my job isn't safe, I don't have the equipment I need to feel safe, something bad is going to happen if you don't fix it, like, doesn't that speak to what would be reasonable for an employer to provide?
Not necessarily, Your Honor. It depends what he's complaining about. I mean, of course, employers get complaints about a lot of things. It doesn't mean every complaint is valid. It doesn't mean what he's complaining about means it's unsafe. I mean, that's really the only key issue here, is what he was doing unsafe? Was there an unsafe workplace? Not he complained about it.
What I understood from the briefs was there were two complaints that I wanted, that one was that his work peer would not lift heavy items, and the other was that the boom on the truck was often broken.
Correct. So those complaints go to his cumulative trauma complaint. So the only specifics, again, his cumulative trauma claim, does the FELA recognize cumulative trauma claims? Yes. That doesn't mean everyone who claims a cumulative trauma injury gets to a jury. I mean, cases are different, the evidence is different. There's really no evidence here. What he's done is made a complaint basically that
My question really is, does that not go towards negligence? And if it doesn't, how does it not?
No, Your Honor. So with the boom truck specifically, he says, well, sometimes I had a boom truck, sometimes I didn't, or sometimes the boom worked, sometimes it didn't. Again, a boom truck to do what? He would have to show evidence of what is the boom truck being used to do? And is his job safe to do without a boom truck? And we don't have that evidence. So if he said, I have a particular piece of equipment or something I need to lift with a boom that cannot be safely lifted
Did he
with,
assert that he had notified the company that, that the boom truck was not functioning?
I'm sorry?
Did he assert that he notified that the boom truck was not functioning?
I think he claims he made complaints about the boom truck.
Okay.
But the issue is, the boom truck only matters if the job cannot be safely done without a boom truck. So the complaint about a boom truck, but whether a boom truck works or not, is only relevant to the extent the job can't be safely done without the boom truck. So for instance, a boom truck may make his job go faster, it may make his job go easier. It doesn't mean it's unsafe to do without a boom truck. That's what he would need evidence of. So he's
And
not,
what kind of evidence would you imagine that he would put out there?
sure, let's say he said, well, there's this 200-pound piece of equipment that can't be safely lifted by hand, and I had a boom truck, and they made me do it anyway, and I injured myself. That might suffice. That's not what he's complaining about. He's just making general complaints about, I didn't have a boom truck. So where,
Why can't the jury make that inference on this record? So he has described that he has to move these bars, we know that from the 2012 incident, and that he has to get the oxygen tank, and that he's moving equipment around, and he's described that this boom truck helps lift things up and down, and that the arm and the thing would break. And then his doctor has said, well, he's performed excessive labor over the years. He's done a lot of work that maybe was too much for his body. Why do those things not add up to a claim?
well, the boom truck, I think, I don't know that it particularly goes to the joint bars, but he would have to have some evidence that he can't do these jobs safely without a boom truck. What we have, and what differs from cases where this has gone to a jury, is he's got no real specific claims. He just makes vague grievances and allegations about his workplace. I didn't, I had a coworker named Teddy I worked with a lot who didn't pick up the slack. Sometimes my boom truck didn't work. Okay, but what were you doing? What did you need the boom truck for? There's just no evidence in the record.
Lifting heavy and moving heavy machinery.
Sure.
right? So that's what he needed it for.
Well, right, but heavy, I guess, is in the eye of the beholder. I mean, he doesn't say what he needed this for. He doesn't say, there's no evidence in the record he couldn't lift whatever he considers heavy without a boom
No,
truck.
he's saying that because he didn't have a truck, he lifted this stuff and it caused him injury
Sure.
because of the continuous strain. Whereas if he would have had a boom truck, it wouldn't have been such strain on his body.
Well, I mean, we don't know a lot of things here, though, Your Honor. So he's saying generally lifting heavy things. Well, what does that mean? Is it unsafe to lift these heavy things without a boom truck? It's not that something causes him injury.
So you're almost suggesting that he needs some sort of expert to say this?
Sure.
We
Yes.
can't just make an inference. He needs to put an expert on that says some sort of industry standard and it's unsafe without a boom truck. Is that what you're,
I would say he would need more specifics and likely an expert to establish that. He can't just say, I lifted heavy things.
well,
and
what if he
did-
did not have an expert but was more specific? Like, I lifted these, like, 200-pound things and it
Sure, I-
strained my
I-
back each time.
Yes, Your Honor, that's what I referred to earlier. So there is case law where if something's so heavy it couldn't possibly be lifted, by a person safely, without machinery, without extra help, I think that kind of
But
case.
how does he demonstrate that? Can he demonstrate that without an expert in your,
I think if he were to say there was a particular piece of equipment and it was so heavy I couldn't lift it on my own, and it's unsafe, like it's 200 pounds or 300 pounds, or something like that, but that's not the
what
record.
if I was so heavy, I could lift it, but it just caused excessive strain on my body when I did?
I think you would need expert testimony for that.
Okay.
And the cases, they only cited, I think, 2 cases that really talk about cumulative injuries in their brief. One of them is the Hardeman case. I think that's actually illustrative of the point here. That was a carpal tunnel case. In that case, the plaintiff was alleging a discrete injury, carpal tunnel. He had ergonomists who went out and measured and quantifiably how often was he doing certain things in a day, what were the forces required, those kind of things, and that they were able to establish, in that case, through an ergonomist and other experts, that here's what he did on a daily basis, here's how much of his time he spent doing these things, here are the forces involved, here's how they relate to carpal tunnel. We don't have any of that here. What we have is just him making generalized complaints. It sounds specific today to a boom truck, and that my coworker Teddy didn't always pick up the slack. So again, it's a negligence action. What he's arguing really here is just, I worked hard throughout my career, and now I have, I guess through the affidavits, he has a bad right knee, a degenerative right knee, and a degenerative neck. But even then, Your Honor, getting back to the point about the boom truck, nobody's tying the boom truck specifically to an injury. So even if you believed, well, it's negligent not to have a boom truck that works all the time, and he couldn't do these things, it was negligent to have him work without a boom truck, someone would have to come in and tie, that specific claim of negligence has to be tied causally to his injury. So nobody came in and said, had he worked with a boom truck, he wouldn't have been injured.
How does this more liberal standard of negligence come into play in these cases?
There is not a more liberal standard of negligence, Your Honor. So that's what there's a different standard of causation, but it's just common law negligence. So the idea that all FELA cases go to a jury, or there's some different lower standard of negligence, is incorrect. The U.S. Supreme Court has made that clear in the Sorrell case. So FELA follows common law negligence, except where it specifically does not, as specified in the statute. So for instance, in FELA, it abolished assumption of the risk.
And do you perceive that to be substantive law that we would apply here in state court, or do we use our Rule 56 procedural standards?
There's case law in Ohio, I think it's Smith versus CSX, which says that you use Rule 56 under Ohio law in determining summary judgment in an FELA case.
And your time is up.
Okay, thank you, Your Honor.
Thank you.
Briefly, a couple points on the law, the FELA. In Mr. Carnes' brief, he points out a different standard for negligence. What he says here is, and this is from his brief, Kelly, who's our liability expert's affidavit, does not create a genuine issue of material fact with respect to CSXT's alleged negligence. Kelly does not opine that the work duties Wilson engaged in were unreasonably dangerous, which is the standard for negligence under the FELA. We are not required to prove unreasonably dangerous. We're simply required to prove it was not a reasonably safe place to work. Further in his brief, Mr. Carnes is stating the negligence statute for FELA as to our causation experts.
What about his argument that, and I'm paraphrasing, but that, that this work is normal kind of work, that sometimes people have to lift heavy things at their job, and that it's your burden to prove by expert or otherwise that it was a requirement to have some kind of equipment to assist with this heavy lifting to make the workplace safe?
If there was never a boom on a truck and no railroad worker in the track department or the welding department ever had a boom, Mr. Carnes' argument makes some sense on defense. The railroad affirmatively made a decision that because welders with these welders truck lift and carry not just joint bars, but these tanks on and off these trucks, he's up there trying to change a tank when he steps on the joint. They made the determination that a boom is necessary to help these guys lift heavy equipment
But
to
we're
and from.
inferring that.
Absolutely.
That's not specifically, anybody from the railroad said this in the record, right?
Circumstantial evidence and inferences is all a jury needs for
Right, but-
purposes of making a decision.
But that's what I'm making sure of here, is that we don't have any testimony from the railroad as to why they put the boom on these trucks. You are asking us to infer.
Absolutely.
That it is for safety reasons.
Just like I'd ask a jury to infer it. Let me talk about the law real quickly, because when the railroad is negligent by any employee, that is imputed to the railroad itself. For example, the language of the FELA itself, 45 U.S.C. Section 51, says, "Railroad shall be liable for such injury resulting in whole or in part from the negligence of any of the officers, agents, or employees of such carrier." For example, if Mr. Teddy Burgraff is negligent, it's imputed to the railroad, okay? So the other thing about it is, and there's a U.S. Supreme Court case called Sinkler in my papers, Sinkler, which says negligence of a coworker, foreman, supervisor is imputed to the railroad.
How do we, though, know that he's negligent? I mean, certainly your client complained about his work ethic, but how do we know that that was negligent?
If Teddy's sitting in the truck, smoking a cigarette, reading the newspaper, having a cup of coffee, and Ed's out there pulling all the stuff off the truck and carrying it to the job site, I think a jury could infer that that guy wasn't doing his job. If he's not doing his job, that makes the railroad negligent. Couple of the, on the law, I want to give you a couple cases that really tell you what the burden is for proving negligence here, because I disagree with Mr. Carnes when he says it's not a liberal standard. Aparicio, Sixth Circuit case, says a scintilla of evidence gets you to a jury, okay? Harbin,
And you're out of time.
Seventh Circuit, pigeon bone broth gets you to the jury. I'll leave it at that. And I
Thank
think we
you.
have more than pigeon bone broth. Thank you.
Thank you for your arguments this morning. We'll take the matter under submission and issue a timely written decision. Enjoy the rest of your day. And our final case this morning is C-240282, In Re GRB. Good morning. Would you like to reserve time for rebuttal?
5 minutes, please. Thank you, Your Honor.
You may proceed when you're ready.
Good morning, Your Honors. Jonathan Hilton for Appellant Samuel Burchinal. May it please the Court. Your Honors, Ohio's law of venue is gender neutral. If you look at juvenile rules 10 and 11, and you line those up with a statute in Ohio that defines a child's residence, which is RC 2151.06, you will find a framework that exists that treats litigants equally in terms of venue, no matter their sex. The juvenile court below in this case believed that it had to send a father's case away from Hamilton County to Toledo, to Lucas County, based solely on the sexes of the parties. And it did this because it misapplied Ohio law. It took a provision that is a substantive default provision that awards legal custody to a mother when no lawsuit has yet been filed, an unwed mother, and it read the word sole residential parent into the venue statute. No other court in Ohio has done this, and the trial court in this case created an equal protection problem where no problem previously existed.
Does this problem that you identify exist on the face of the unwed mother statute itself, or is the problem in its application to venue?
In its problem to application of venue, and here's the reason why. Chapter 3109.042A serves a substantial government interest on its face. And that interest is in giving hospitals, schools, the police, a default rule to follow so that they can make quick, bright line determinations when decisions have to be made quickly as to who to return a child to when there's a dispute between an unwed mother and an unwed father. And in that case, there's a substantial interest in returning the child according to a quick decision. But if you look to cases like Stanley versus Illinois from the U.S. Supreme Court in 1972, or Reed versus Reed, what you find is that the government's substantial interest in having a quick, bright line decision made.
Counsel, has either party notified the Attorney General about the challenge to this particular statute?
No, Your Honor, and I'll give you two reasons for that. The first is that the notice provision only applies when a party files a declaratory judgment action seeking to have a law entirely invalidated.
Well, you're asking Mother to, in some sense, defend the application of a state statute and thereby to assert the government's interest in this statute. And isn't that a really big ask of one individual person?
It's not the statute itself that we are attacking. It's the trial court's order below, which is an interpretation, it's a misconstrual of the law. So as we argue, the relevant venue statute is found in Chapter 2151. the law that the appellee is attempting to have applied here isn't even a venue statute. So, in fact, if you look at.
Isn't that the bigger issue here, the statutory construction issue, that you've identified a statute and the trial court applied a statute that's more custodial and less procedural?
What we're seeking to do is have the doctrine of constitutional avoidance applied to an issue of statutory construction. So merely to be able to argue the constitutional avoidance route for interpreting a set of statutes, you would not need to put the Attorney General on notice of a declaratory judgment action. To do that would invite notice in cases where really all we're arguing is statutory interpretation based on that doctrine.
Let's assume for a minute that we're more interested in the narrower statutory interpretation question and less so the bigger constitutional question. Can you walk us through just the straightforward textual application of these statutes and why it would produce the result that you think is correct?
Yes, Your Honor. So if we start with the Ohio Supreme Court's decision in re ZR from 2015, the Ohio Supreme Court identifies in that case the relevant chapter of the Ohio Revised Code for deciding venue in juvenile cases as at Chapter 2151. When we turn to Chapter 2151, there is a specific provision that says that the residence or legal settlement of a child is the residence of its parents. It uses that word parents, plural.
Well, hold on a second. So I understand that piece of it. My understanding is that 2151 also provides that you file the complaint where the child is found.
Yes,
or
Your
last
Honor.
known to be found. And that's very interesting language. It doesn't say where the child's residence is.
So the reason that there is a discrepancy between the language that's often used in the juvenile rules about where a child resides, for instance, Juvenile Rule 11, versus where a child is found or was last found, is that the term where a child is found is intended to be broader than residence. If you look to the Witt versus Walker case out of the 2nd District, you'll see that a child's residence is included in the definition of where a child may be found. But the reason that that language is broader is because anyone in Ohio can file a custody suit. For instance, a child may be living with a grandparent. It may not be clear where the parents reside. So the grandparent can file that suit to obtain custody where the child may be found, and that's going to be broader than just residence.
If the child is living with the grandparent?
Correct.
And so then the child, the grandparent's residence would not be considered the child's residence?
If the grandparent could make a showing, a factual showing, that they were acting in loco parentis, then possibly.
Okay.
But that would be, that's a complicated determination to make at the threshold. And by using that broad language, as the Witt versus Walker case explains as well, you also might have the case of a child who loses its residence and because their parents have moved to other states, for instance. And in that case, you need that broad language. But if you think about the Juvenile Rule 11 and how it structures the transfers of venues, that rule assumes that venue is always going to be proper in a county where a child resides. It always allows for a case to be transferred to a county where a child resides. So
are you saying that this was governed by Juvenile Rule 11 ultimately?
yes, Juvenile Rules 10 and 11 are going to be the starting place.
And I believe that you're also asserting that there was error because the trial court treated this as a mandatory transfer.
Correct. In the court below, the defendant only moved for a mandatory transfer. The defendant didn't move at all based on the interests of justice or any other reason to transfer. And the defendant's two-page motion didn't assert any of the traditional things that a court might consider in the interest of justice. There was no discussion by the defendant of where evidence would be, where witnesses would be, the
This
history of...
wasn't an alleged inconvenient forum case.
Not so much an alleged inconvenient forum, because the defendant never asserted the forum was inconvenient. The defendant simply asserted that she was the sole residential parent based on Chapter 3109.042A.
And it's your position that the statute renders that claim untenable because the child had two parents at the time?
Correct. Under Ohio law, the child had two parents, and the residence of each of them would count. If you look to...
But that goes back to Juvenile Rule 11, does it not?
Correct.
Okay.
Ultimately, the starting place is going to be Juvenile Rules 10 and 11, which define where the complaint should be filed and to where it can be transferred. And then after that...
It seems to me that the trial court was applying Juvenile Rule 11B. Would you agree or disagree with that?
Right, and that's the only part of Juvenile Rule 11 that the trial court applied.
And that's the mandatory transfer.
Mandatory transfer only.
And there was a whole discussion on child's residence under 11B.
Exactly. The trial court believed that a child could only have one residence, and it went outside the rules of procedure, and it went outside the relevant statute as defined by the Ohio Supreme Court in Ray ZR.
What I find interesting about that statute is the language that comes before that portion that everyone focused in on, which is, that basically says when there's proceedings elsewhere. And in this case, mother's filings take place after father's filings. So when father files, there are no proceedings elsewhere.
Correct, and that is another reason why the trial court below should not have applied Rule 11B.
So if we were to determine that that the trial court should not have applied 11B on the plain language of 11B, then do we even need to reach the constitutional arguments?
No, Your Honor, you would not, because on the plain language of Rule 11B, if you're looking at venue at the time the case is filed, there are no other pending proceedings. The juvenile court's sole basis below was Rule 11B, and the supposedly mandatory nature of the transfer, given the later filed case by the mother in a competing county. So at that point, the juvenile court's decision would be reversed, and the case would have to be remanded.
But does 11B require, when it says are pending, does it mean at the time that the original complaint was filed, or, because clearly the mother's case was pending when the transfer occurred?
So I want to draw a distinction, Your Honor. If you're talking about measuring whether venue is proper in a case, as opposed to whether there should be a discretionary transfer, but whether venue is proper in the first instance, you have to do that at the time the case is filed.
But I'm just saying with regard to 11B, the mandatory transfer, does that require that the mother's case be pending at the time that the father's case was filed?
Correct.
But where does it say that?
So that is a background rule called the time of filing doctrine.
Okay.
I cover it in my opening brief toward the back. I give a few cases. One is OA versus Trump. But that is a foundational rule of venue construction that has existed since the time of the founding. And the reason for that is because otherwise you can have all kinds of shenanigans where parties attempt to destroy venue that was proper at the outset of the case.
And counsel, you're out of time.
Thank you, Your Honor.
Thank you.
May it please the court, I'm Scott Greenwood, and with Mr. Moskowitz, have the privilege of representing the mother, Taylor Dunlap, the appellee in this case. This case is very straightforward and really turns on three key points, all of which are really fatal to the appeal. First, we have the statute. The unwed mother statute is a starting place. It's not conclusive, but it's a starting place. It's the default.
Why does that apply to the venue inquiry and not just the custody inquiry?
So it applies to the venue inquiry in that it's a lot like a habeas corpus case with a child. So a minor child of an unwed biological mother is presumed to reside with that mother wherever that mother resides, whether that, and there's not a restriction on where that parent lives.
So is it the case then, playing that out and playing out your interpretation of that statute, is it the case then that when there is a child born to an unwed mother and father, that the father will always have to file a custody suit in the county of residence of the unwed mother?
Yes, Your Honor. And that's the starting point. But the statute clearly also says that the court has to treat those parents equally. So it's just the default as to where it is filed. And that's because it's easy.
Is then, and I realize these are hypotheticals, but in that scenario, is juvenile rule A available to the father to say, this is an inconvenient forum because all of the evidence pertaining to this child, the experts, my residents, family members, et cetera, exist in County B. And so you should engage a discretionary transfer to send this case to another county.
So I think, Your Honor, that procedurally what would have to happen is the case has to be filed, venued, where the child is found, in this case, Lucas County. Father has to make an appearance there. Father then has total ability to file a motion for precisely the reasons that the court suggests about the forum inconvenience and request a discretionary transfer. So it's a little procedurally more complicated, but they're bright lines that way. It's not a race to the courthouse. And what the appellant's position does.
And could father have done that here? Could he have filed in Lucas County and then said Hamilton County is the appropriate venue because the child's pediatrician, et cetera, are all in Hamilton County?
Yes, Your Honor. That procedurally is exactly what the father should have done to assert his parental rights and to allocate the parental rights and responsibilities. File in Lucas County and then file a motion to transfer it to Hamilton County.
All right, so then what we've described, I think, your opponent would describe as placing a unique and burdensome requirement only on fathers. And why is that not an equal protection violation?
It isn't an equal protection violation, Your Honor, because we're just starting one place. We're not determining the entire proceedings, and it certainly is not based upon sex. There's nothing in the statute, there's nothing in the trial court's order in which there's a distinction that's made here that's based upon sex. We're assuming it's based upon sex because there's a biological mother and there's a biological father. They were in a relationship that no longer exists, but the statute is neutral. The statute does not create a distinction based upon sex. If it did, then every determination of
And the
custody.
neutrality that you're referring to is within the word found? Is that because it's covered by found?
Yes, Your Honor. And found is, again, this is, conceptually, it's quite like habeas corpus. So you can only file the case where the child may be found. And all the statute does is say, as a starting point, this is where the child may be found with the mother. And that has no bearing on anything beyond that
But what's
point.
interesting in this case is that the child, the mother, the father were all living in Hamilton County for a period of time. and mother went to visit parents. That's the way it was understood by father. And then, lo and behold, it changes. So, at the time that he's filing, mother was in Lucas County for an incredibly short, brief amount of time, and it was supposed to be to visit parents.
I don't think that is an accurate description of what occurred, Your Honor.
Okay.
And I think there's another key fact that really forecloses this appeal. The petitioner pled, and it was admitted in an answer, that the child lived in Lucas County, and that's where mom lived too. And there was a recognition that the child and the mother were not residents of Hamilton County at that point. This was a relationship that ended, and father thought this was final, clearly, because father filed the petition. This wasn't a visit. Father filed a petition.
Well, counsel, isn't the residents that we're concerned about, I think, and I don't want to put words in anyone's mouth, but I think everyone is clear that mother's county of residence counts for venue purposes. I don't hear either of you to be saying that mother's county of residence doesn't count.
Correct.
What is in dispute is whether father's county of residence also counts. And I hear your position to be that it doesn't count because the unwed mother statute requires fathers to file there rather than in their home county.
And there's a good reason for that, Your Honor. The reason that the unwed mother statute requires this is because unwed biological mothers do not file custody petitions for their children. They don't have to do that.
But didn't that occur in this case?
In this case, what happened was competing petitions. So the default, what normally happens is, as occurred here, the father filed a petition. That's the way it works almost all the time. And where the parents are in the same county, it doesn't create a venue issue.
So I
Clearly.
asked a hypothetical to your opponent about the discretionary, or to you actually, about the discretionary transfer. Could mother have done that? So could mother have moved for discretionary transfer rather than filing her own petition in Lucas County? Could she have said, actually, the more convenient place, the better place is Lucas County because that's where I now am, that's where the child now is, that's where we're going to be making a life, this is the appropriate venue. Could that have occurred?
I think, Your Honor, it could have occurred. I think mother could have filed a response that included a motion for a discretionary transfer, but she didn't need to because Juvenile Rule 11 has a mandatory transfer provision.
And do you agree that that was all that was asked for below, was 11B transfer?
Yes, Your Honor. Yes. And I think the final of these 3 points that I want to emphasize is that it is impossible for the court to find an equal protection problem here without invalidating the unwed mother statute. It is impossible for you to do that. And if you, in order to raise that issue, father should have notified the Attorney General with a declaratory judgment action. There's no indication that father has ever brought this to the attention of the state of Ohio. And
Do you have an understanding, and I realize this places a very large burden on a singular person who's not responsible for the enactment of this statute, but do you have an understanding of why the legislature may have enacted this provision or what the substantial interests might be behind it?
there are several substantial interests, Your Honor. One of the substantial interests, because if it is drawing a distinction based on sex, which I would not concede, it is to have a bright line so that parties in these disputes where ultimately there will be a judicial allocation of parental rights and responsibilities, they know where to go. It is not a free-for-all. It is not based upon file wherever you want, wherever anybody resides.
Well,
Because
isn't that kind of, sort of establishing administrative order? That sort of government interest was of the variety that was rejected in cases like Reed. So why is that something that would rise to the level of being substantial?
Your Honor, it's not administrative order for the convenience of the government. It is for the certainty of the parties, that parties know that if they separate and seek to allocate parental rights and responsibilities, they know where to go. It is absolutely clear.
That was exactly the same in Reed with, the will contest and needing an executor and trying to establish certainty for families in time of need. I mean, it's the exact sort of thing the government was saying before. And I know this puts a burden
Sure.
on you, and you're not here to defend what Ohio did.
So, Your Honor, in Reed, recall this is that's a case that involves executors, right? It does not involve allocation of parental rights. And because of the status of these parties, I think this is more complicated because it kind of looks like an equal protection issue based on sex, but the distinction here is not based on sex at all. It's based upon the marital status of the parents, and that's a little bit different. And so it's gender plus marital status. And there really is not, there's no other way to describe this than to say that the statute is there to provide clarity to the litigants and as a starting point, and it is to deter people from a race to the courthouse, to get some perceived tactical or strategic advantage in a home county. What the appellant's position would do, not just in this case, but in other cases, is essentially tether people who are in relationships that end. It would tether people to the county of whichever parent filed first. And because we have the statute, 3109, mother is not going to have to file a custody petition, but if the court made a determination that what occurred here is an equal protection problem, then unwed mothers will have to file custody petitions for their own children in order to get that perceived tactical or strategic advantage from the beginning. And I don't,
So your argument is that venue is always improper from the beginning when father filed in Hamilton County, and it should have been filed in Lucas.
it was required to be filed in
Because
Lucas
of,
County.
because of 10A.
Because of 10A.
And that is because the child was found there.
That's the only place that the child was found as the appellant pled in his
Are you
petition.
equating being found with residence, though? Or is it just that if she was just on vacation and she didn't establish residence up there?
She wasn't on vacation, Your Honor.
No,
and-
but I'm just asking if she was just visiting her parents and she wasn't establishing residence there. Is it that the proper venue because that's where the child is found?
It's the proper venue because that's where the child is found, Your Honor. And the rule uses the term found as opposed to residence quite deliberately.
Well, what if mother went on a vacation without the child and left the child with dad, and then dad filed, and the child was found in Hamilton County, and mother wasn't would Hamilton County then be appropriate?
Then I would agree that it would be appropriate at that time, but if the parents are then separated, you go back to the statute. The statute says the residential parent is mom.
Doesn't your interpretation, and I understand the words is found, those are kind of awkward and different from defining venue by residence, but doesn't interpreting is found to literally mean where the child is actually located at the time of filing encourage child kidnapping, encourage taking children for the purpose of strategically moving them around so that you can gain a venue advantage?
Your Honor, I think that is a hypothetical that is not shown to be something that actually occurs in the real world. The reality is that the contrary position would mean that people can never relocate. My client returned home, and a contrary ruling that tethered everything to Hamilton County would essentially have restricted her from relocating.
I don't think they're arguing that everything is tethered to Hamilton County. I think they're just arguing that he filed first. There was nothing preventing her from filing first, right?
There was nothing that would have prevented her from filing first, except that because of the unwed mother statute, she's already determined, again, presumptively, until a court of competent jurisdiction makes a determination otherwise, she is the residential parent. She is the custodial parent.
They raised a few more sort of interesting hypotheticals in their brief that I'd like you to address with regard to this is found language. One of them was, that a parent resides in a particular county and the child goes away to summer camp. Does that then preclude the parent from filing all summer because the child is not physically found in the county at the time?
I think at that point, Your Honor, the court could determine that the child is found where the child's biological mother resides. You would then have to read the rules consistent with the statute. So that's where the child would be found, a temporary absence notwithstanding.
So temporary absences are contemplated by the language is found.
I believe so, Your Honor.
All right, thank you, and your time is up.
I wanted to follow up. So I was asking you about a situation where, let's say, mom and dad are living together, and they get in a fight, and mom leaves and goes to her parents, but leaves the child with dad. Dad then files for custody in Hamilton County. Mom's in Lucas County. You were starting to talk about, well, I asked you if venue would be proper in that instance in Hamilton County, because the child is found in Hamilton County, and I thought you said, yes, venue's proper. But then you started to talk about something else, and you got interrupted, and I was trying to understand what would happen next. Is venue proper in that instance?
I think venue could initially be proper.
Because
in
the
that
child is
instance.
found in Hamilton County.
Correct, Your
Okay,
Honor.
then what?
And then the mother, if the mother relocates, she returns
Yeah,
home.
say she decides not to come back. She got in a fight with dad, left the child behind, and she's like, I'm not coming back.
And I think at that point, mother's remedy in Hamilton County would be to file a motion to transfer to wherever it is that she's going to live.
To Lucas County under 11A?
Then I think it would, there.
That would be a discretionary
It would be a
transfer.
discretionary transfer, because
Okay.
the child was found. If these people had stayed together and been together, there's no question but that proceedings could occur in Hamilton County. What happened, though, was they broke up, she went home. And finding an equal protection violation because the statute and the rules are so clear about where the case has to be venued, at least initially, that's just a road the court does not need to go down.
I do have one more question. I want to go back to Juvenile
Yes,
Rule
Your
10, where it says that complaints for custody shall be filed in the county where the child is found. And I want to focus on what comes after that, or last known to be. So why couldn't it be said that Hamilton County was where the child was last known to be?
Because, Your Honor, it's pled by the father that the child is actually in Lucas County. It's not a hypothetical at that point. We're not talking about a disappeared child. I mean, the statute, the rule there is to provide some venue, some place where a case could be venued if there's a lack of clarity about where the child is. And that's just not the situation that we have.
That's what I'm trying to get to. How do we know that that only applies when there's lack of clarity? So even in a case here where there is clarity, where I'm going to, let's say I agree with you that there is clarity based on the pleadings. The child was also just recently in Hamilton County, long-term, in fact.
So I think, Your Honor, that there isn't really a look-back period. If you have certainty as to where a child is, that's the only place. If you don't have certainty, then that other clause of Rule 10A would
See, because
would
the reason
apply.
I find it interesting is because I hear what you're saying, and that seems to be the logical answer. But then when you overlay Rule 11 on top of Rule 10, then that's when it becomes illogical. Because then when we go into Rule 11, we're talking about residents, and we're talking about, we've been talking about B because this proceeded as it was mandatory, and the parties didn't look at A or C, which gave the court authority to retain a proceeding, and it seems to give authority to retain proceedings regardless of 10A. Do you see what I'm saying?
I see what you're saying.
And so it seems like because of that or last to be known may have a broader reading because the overlay of 11 with 10.
I think the overlay of Rule 10 and Rule 11 really requires, what it creates, this construct between the statute and the rules is certainty for the litigants, certainty for the child, and it does create a procedure in which if it's the wrong place because there are witnesses elsewhere, that the court can transfer it. So there's been no assertion at all that the juvenile court in Lucas County couldn't have a hearing and make that very determination about whether the case ought to be sent back to Hamilton County. But that's not where we are.
But it also seems like there's no hindrance in Hamilton County making the determination as to whether they're going to transfer the case to Lucas County or not.
So
It does.
it's
what you're-
mandatory. I mean, I believe it's mandatory, and I think the court has to review the venue decision for an abuse of discretion. And there's been no abuse of discretion. In order to find that, you'll have to invalidate the statute, and if you invalidate the statute, then
But you're finding it mandatory based on child's residence.
Yes.
But there's a whole bunch of language that comes before that deals. So in this case, this isn't a case in which the case is first filed in Lucas and then later filed in Hamilton. The Lucas filing comes after.
that's correct, Your Honor. And again, that is because with the statute, the unwed mother statute, it's because mothers don't file petitions for their own children, with rare exceptions. So fathers file those petitions because we know who the parent is, we know who the mother is, and simply filing an acknowledgement of paternity is not equivalent to a court determining parental rights and responsibilities. Are there any further questions from any members of the court? All right. I would ask that you affirm the decision of the trial court.
Thank you.
Thank you, Your Honors. Bringing the matter back to the issue of statutory interpretation, if we look at Chapter 3109.042A, we'll find that in that provision, it says that courts, when they deal with mothers and fathers, should treat them, quote, on an equality, unquote. This line is key because what it tells us is that Chapter 3109, when it talks about the substantive decisions that are made out in the world by the police, schools, and hospitals before a case comes into a courtroom, those are the ones where the government and the state of Ohio has a substantial interest in having a quick determination made as to who is the legal custodian of the child. But the entire chapter is not unconstitutional, and this court does not have to strike it down. And the reason for that is because the government's interest, as the Ohio State Legislature acknowledges in that line about courts being the exception of, the courts are the ones that must treat the parties equally. that acknowledges that the government's substantial interest in there being any difference in treatment ends when the
Counsel,
parties come to court.
Juvenile Rule 11B requires transfer if there are proceedings involving the child pending in the county of the child's residence. There has been an argument made in this case that the child's residence factually on this record was in Lucas County because father's complaint identified it as such. Can you address that?
Yes, Your Honor. If you look at the complaint, the allegation regarding the minor child is that the minor child currently resides with Ms. Dunlap, the mother. The complaint goes on to detail that that has only been for 12 days, and that is how the child is in Toledo at that point.
So that's a factual description rather than identifying the child's legal residence?
Correct, and the key point here is that the complaint does go on to list the father's residence. So venue is proper under Chapter 2151, based just on the father's residence.
And what about the fact that it says the child's residence in the singular and not the plural? Are we to do something with that?
Are you referring to juvenile rules 11B?
Yes.
So a couple of points on that, Your Honor. One is that if you turn to Juvenile Rule 10, you'll actually find an inconsistency where in Juvenile Rule 10A, there is a discussion about a county where a child is a resident. So if you look, that's point one, is that if you read it, you'll find that singular descriptions about residents, the rules over in Rule 10 actually do presume that you can have more than one residence. But the second thing that I'll point you to is the case In re Estate of Quick out of the 7th District. In that case, there was a statute on point that had a very similar issue with it as what the court is describing here, which is that the statute referred to the county where the decedent was a resident, the county, so it was singular. Nevertheless, the 7th District, turning to Black's Law Dictionary and History and Tradition and other case law, held that a decedent could have more than one residence at the time of death. So I would point to those two things. One, that residence is not singular in other parts of the juvenile rules, and then the second being In re Estate of Quick.
So it's just sort of a drafting formality and we're not to read anything into that?
Correct, Your Honor. And given that my client's reading of the statute, Chapter 2156, together with the juvenile rules is what creates a fair system, I would point you to another provision, which is Chapter 2151.01, which is called liberal construction. And that provision says that all of these rules should be applied in a fair and liberal way that is designed to afford the parties their constitutional rights.
And a few hypotheticals for you to sort of test the bounds of this. So under the construction that you're proposing, could mother have gone to Lucas County and filed there?
Absolutely. Mother could have filed in Lucas County first if she had.
And could father have filed for 11A discretionary transfer back to Hamilton County if that occurred?
Yes, Your Honor. Yes, because 11A refers to if the child resides in another county, and the child would be resident in both places. So mother could have moved for an 11A discretionary transfer in our case rather than starting a competing case, and it would have also been true vice versa.
All right, and so the construction that you're advocating for just places these two parties sort of on equal footing, and really it's a first-in-time situation.
First in time, unless then the juvenile court makes findings based on the interests of justice and sends the case appropriately to another county.
And is it possible that that could still occur?
Your Honor, that issue will very likely be litigated below, and I'll just preview two arguments that I would make below if and when the other side files a motion for discretionary transfer. One is that Juvenile Rule 11A says that the appropriate time for filing that discretionary motion is upon the filing of the complaint or after the merits hearing. In this case, the defendant filed an answer in April of last year, and they had already previously filed a motion for a mandatory transfer. So I contend that at this point, they've waived the ability to ask for it under that rule. That being said, I do anticipate the other side will file the motion, and that will potentially then just be litigated in front of the trial court in the first instance.
If my colleagues have no other questions, your time has expired.
Thank you, Your Honor.
Thank you. We will take the matter under submission and issue a timely written decision. Thank you for your arguments this morning. Have a good rest of your day, and that concludes this morning's oral arguments.
All rise. The Court of Appeals starts the